Welcome to the Agents Angle, where this week we cover a highly anticipated development in the football agents world that so many have been waiting for, but may have turned out to be a bit of an anticlimax.
Yes, the primary focus of today's episode is the release by the Advocate General of his opinion, which will now go to the European Court of Justice on the cases relating to the FIFA Football Agent Regulations.
But if one piece of agent-related literature wasn't enough for you, we also take a glimpse at the FIFA Ethical Recruitment Guide that seems to be targeted towards agents.
All that to come with me, Peter Paleologus,
and me, Jonathan Booker,
on this episode of The Agent's Angle.
This week's episode of The Agent's Angle comes to you with more than a fair dose of legalese and mentions of the ECJ and our old favourite FFAR, or FIFA Football Agent Regulations. And usually we like to vary up the topics on the show. But whilst it's not really a landmark development in the world of football agents, as it was an opinion rather than actual judgment or ruling, the publication in recent weeks of the Advocate General's opinion at the ECJ, European Court of Justice, is something that agents, FIFA and the football law fraternities have long anticipated. So understandably, we're going to focus on that development from the ECJ in this episode, and we have a true leading expert joining us on what is a very complex topic that brings together not just one area of law, but several. And of course, for what it's worth, we will throw in our own two penneth from various angles.
Yes, Jonathan, everyone in the football law space, as well as the football agent space, have been anticipating this opinion. But we will get to the Advocate General opinion topic shortly. However, as we mentioned in the introduction, FIFA launched the FIFA Ethical Recruitment Guide, which they say is a crucial step in reinforcing the integrity of the global football system. This guide, which just came out, I think last week, was developed through a survey of football agents and an extensive consultation process with the FIFA Football Agent Working Group. I'm actually a little perplexed with this, not so much the ethical guide, because ethics and transparency are fundamental to our business, but which agents and which sources were involved. Now, I know that FIFA got consultants, Mission 89, a very important NGO, if I can call them that, who did the CPD module for FIFA in relation to trafficking. They were part of this, but I didn't know that the FIFA Agent Working Group was part of this, nor any agent focus group. So that's all news to me. But I just want to go into the nitty-gritty of this guide, and I'm sure most agents would have seen it or are going to look at it when they do have time. Obviously, FIFA aims to protect the game and its players and its representatives. And the philosophy behind this guide, as FIFA has put in some of the comms that have come out, that football agents need to understand the interplay between personal values and ethics that they hold as individuals and professional ethics, which they must adhere to as FIFA licensed football agents. And this is the FIFA Ethical Recruitment Guide's main aim. It sets a new global standard for how players and coaches are recruited by agents in international football. I'll just go really briefly into some of the aspects that are in that guide. It's a big guide. 1, zero fee recruitment. Players and coaches can't be charged for being recruited by agents. Mandatory written offers in terms of the way agents will sign clients. Full disclosure of payments. Now, there's a bit of a mention here in the guide about the FIFA clearing house, but that hasn't really got off the ground. As we know, there have been issues with that, Jonathan. Due diligence on agents and recruiters, emphasis on clients and FIFA and everyone looking at license checks, the discipline history of agents and the conflict screening in place. And one interesting one, as we know, probably more so in the mandate world, that agents cannot keep copies of passports. I know with mandates, players give a passport to support the mandates or other IDs that cannot be held by agents. And also, it's got a scouting element to it as well. So it's quite extensive for football agents to consider. And the final thing I will say, there are checklists in this that agents can use. And there's a FIFA Code of Conduct for football agents, which I would have thought would have been circulated by the FIFA Agent Working Group to member associations, comments by agents. That hasn't happened. So there's a lot of work has gone into this guide, but it's been just presented. And I don't think agent associations or people in the FIFA agent working group have come back to the agent population to get feedback on this guide. So I urge everyone to read it. It's an important guide and ethics is fundamental, but it puts a lot on agents.
I have read it, albeit briefly, and can definitely see the value in such a document, well, at least for some. Because personally, I found it a tad patronising because most of it, professional agents should know. And also, the language, given the backdrop of the FFAR saga, seems a bit misguided, referring to agents, I don't know, was it heroes or something like that? And I also thought it was very repetitive. 85 pages, I think it is, when possibly 20 would have sufficed. And there may also be a hint of AI generated content or possibly throwing multiple documents together from several different sources because of that repetition. As with so many things at FIFA, it seems the aim is laudable, but the execution a bit misguided. Because as with most things FIFA do over the last few years relating to agents, there is a lot of skepticism. And in this document, and you touched upon it, FIFA continually refer to, one, the AWG, or Agents Working Group, and two, the fact of agents being surveyed. So the first point, the AWG and their contribution to this document. Now, there's some disagreement over this. Some members of the AWG claim they weren't aware of the document, let alone put their name to it or contributed, whilst others say they were presented with the document but didn't really contribute to it. So is the AWG being used as a vehicle to legitimise this and further present that false narrative of consultation with agents? Or is it a case of the very FIFA-friendly members of the AWG being consulted as they will likely do what they're told without much fuss or questioning it? And that leads me on to my second point about the surveys of agents that FIFA refer to in the document. There is no mention of how many agents were surveyed. There's just a percentage, what they were surveyed on, their demographic and geographic locations, or when these surveys were undertaken. For all we know, these could again be a small subset of FIFA-friendly agents, maybe linked to an association represented on the agent working group, whilst a vast number of others are omitted. And thus we get this false representation of what the true picture is amongst FIFA agents and the way they're finding things. And that doesn't really help with this document, the ills of the industry or those affected by it.
Yeah, I think this document tries to address a lot of themes. It's a very good guide in the sense of its aims. We all want ethics. We all want transparency, I mentioned before. More guidance, more good guidance is always required. And one good aim, of course, is to reduce the exploitation and trafficking of young players. We've all got to be aware of that issue. And we've had someone on the podcast about that crucial trafficking of players, fake agents. We'll see how it goes. It's obviously going to be integrated in the FIFA agent space. However, I think it's time now to go to what really this episode is about, the Advocate General's opinion.
And it just so happens that FIFA Ethical Recruitment Guide arrived in many an in-tray and also on the FIFA website roughly about the same time as we were expecting the opinion from the Advocate General at the ECJ on matters relating to the FIFA Football Agent Regulations. And there's been quite a bit of commentary regarding the AG's opinion. Some of the commentary has been speculative, some has been thoughtful, and some was quite knee-jerk reaction, really. And we're going to go to pass the floor to our guest on the main thrust of the opinion itself, and after that, throw in our own observations. But just to start, Peter, I was wondering what your initial reaction was to the opinion's release, rather than the opinion itself, as we'll come back to that later on, and also some of the reactions and commentary that surrounded it. Because for me, I was a bit underwhelmed by the opinion itself because it seemed somewhat inconclusive and vague. And secondly, whilst I appreciate there may be possible legal reasoning for rolling three cases in together in the opinion, this muddied the waters in some ways and potentially leaves more questions than answers, not just for the non-lawyers, but the lawyers as well.
Yes, as you said, there are three opinions here. Personally, I'm a bit underwhelmed with the opinions. I think they lack definitive indications of what outcomes might result from the court's decision. The first thing came to mind reading the three opinions, but especially the two that related to the German agent cases. It's a 50-50 opinion for me, or in football parlance, a draw, I would say, between the agents and FIFA in the way this opinion has been set out. People expected more favourable for the agents, but I think it's definitely a draw. And we'll see where the court lands on a lot of these issues. They might go one way or the other. So it's really left up now to the judges of European Court of Justice to make a more definitive decision. Some say, especially in terms of the caps, the way the opinion comes across, that allows FIFA to win their cornerstone argument on the caps, and we'll dissect that a bit later in the podcast. But there is some people who think that FIFA have argued a good case in relation to the caps. But for me, I'm big on what's next. And we know, and there's been one or two cases where the court doesn't follow the Advocate General opinion. But what I want to see from the courts is to provide more thorough guidance on the applicable European law in relation to the FIFA Football Agent Regulation. We need something more definitive. Why? Because we've also got the cases from the Netherlands, from Belgium, and from Spain, I believe, being referred here in relation to similar things about the FFAR. So whatever decision here, we'll deal with those cases as well, hopefully, so we don't have continued uncertainty. The key thing here is the FFAR in a lot of its measures necessary and proportionate? And it all is based on that. It's not clear from this opinion. The opinion does say what needs to be done, proved by FIFA or the agents to get their case across the line, Jonathan.
Now, in terms of the reaction to the opinion, two key reactions I was looking out for. And the first was the agents' associations. And they did seem to be quite measured and somewhat reasonable, especially as during the whole FFAR saga, some of their comments and statements have been a bit inflammatory, if not unprofessional. But I don't think this was necessarily the associations being subdued or even resigned to a loss, which some people have concluded. Now, on the other side of the battlefield, I also think FIFA's response as an organisation was quite moderate, at least compared to what has gone before with their comments on FFAR, despite there being an undertone of confidence from FIFA after the release of the AG's opinion. However, on the topic of FIFA, what did initially annoy me and frustrate me, which over time and with a bit of reflection turned more to amusement, was what I am now calling the narrative of nonsense peddled by FIFA on the FFAR. And this is this continuing mantra where they refer to the FFAR being, one, the result of a long and inclusive consultation process, and two, the FFAR being fully justified and provide a transparent, reasonable and proportionate framework to help resolve systematic failures in the player transfer system. Because I think we've established over time, as have many others, that FIFA are very much in the minority with their interpretation of what consultation is, let alone it being considered inclusive. And there are plenty of justified questions over whether FFAR is reasonable, proportionate, and justified. And I think that is also evident from the AG's opinion. But the thing that did grate with me is not so much the reaction of FIFA as an organisation, but people within FIFA almost crowing and lauding the opinion as a victory. Firstly, some of the people connected to FIFA should hold fire on all the backpatting over FFAR, certainly not go around awarding plaudits to colleagues. And secondly, those at FIFA who were directly involved in the development of FFAR, I think there is only one person who remains at FIFA from the early days of FFAR, and arguably two if you want to take it from the point of the claimed FIFA consultation process. And if they truly have been involved in FFAR, say prior to the move to Miami, I don't think there is anything to be proud of with FFAR or the farcical process that's gone on around it, not least wasting so much money that could have been invested far more wisely and productively elsewhere. And I can't help but think that possibly this reaction from some at FIFA almost had an element of relief to it, because they expected the AG's opinion to be far more critical of FIFA and the FFAR. But as we've already said, this opinion was rather non-committal and equivocal. So to react in such a way seemed a bit presumptuous by some people at FIFA to almost react to it as though it's a victory.
Jonathan, I didn't see all the reactions from FIFA. I did see one, and also the general release, which FIFA welcomes the opinion issued today of the Advocate General of the Court of Justice of the European Union in relation to the FFAR. We know that FIFA and their lawyers put a lot into this case. And we also know from one or two people who were at the hearing that the judges asked a lot of questions, not just of FIFA, but also of the German agent's lawyers. So a lot of questions were asked by the judges in order to get down to what are the main points being argued by both sides. Now, I think it's time to turn to our esteemed guest to unpack Advocate General Emilio's opinions, times three, I should say, three opinions, but mainly the two ones that we're really interested in. Today, we are pleased to be joined now by Stefano Bastianon, one of Europe's leading experts on European and sports law. With the Advocate General's opinion at the European Court of Justice now published regarding the FIFA Football Agent Regulations and the relevant German cases that were referred to it, we wanted to step back from the technicalities and instead get a clear, practical insight of what could all mean for agents, agencies, and players, as well as clubs. Stefano, thank you for joining us and for helping to make sense of such an important moment for the football agent world.
Thank you very much for inviting me. It's a pleasure.
I'll begin in very simple terms. Can you just summarize, Stefano, what the Advocate General's opinion says about the FIFA Football Agent Regulations?
Well, from a preliminary point of view, the Advocate General says that the FAR case is not an outcome case, a case where the Court of Justice does not leave the referring court any discretionary power. By contrast, the complex legal and economic context of the FIFA regulation does not allow the Advocate General to provide a clear-cut assessment on the compatibility of the FIFA rules with EU law. And this is a very important point. On the merits, the Advocate General is of the opinion that none of the contested rules, with the only exception of the rule on making an approach, constitute a restriction by object. This is a very important finding because this means that the referring court shall assess whether the rules may produce an anti-competitive effect, and in case the referring court will end up saying that these anti-competitive effects are actual or potential, if they may be justified under the Mica Medina test or under Article 101 of the treaty. And I think this is a very important point and a clear signal in favor of FIFA. Because if the rules are not restrictive by object, everything is possible. You can argue that they pursue a legitimate objective, that they are necessary, that they are proportionate, and so the story is still to be written. I mean, it's not a final say by the Advocate General, and we will see what the Court of Justice will say, because we don't know. Maybe the Court of Justice will follow the Advocate General, and so everything will be for the referring court to decide. Or maybe the Court of Justice will say something more precise, and then we have to wait for the ruling.
Is there anything that surprised you about this Advocate General's opinion? You mentioned that it wasn't totally clear-cut, but is there anything that surprised you? I know there was three opinions, which was quite interesting, and you had to read all three to understand the full picture, but did anything surprise you about this AG opinion?
Yes, you are perfectly right. I mean, again, from a general point of view, I think it is quite interesting that the Advocate General says that the three cases, I mean, the FAR case, the Rogon case, and the CD Tondela case, are the follow-up of the Christmas trilogy, ISU, Super League, and Royal Antwerp, and the Diarra case, the last one. And it is also important that the Advocate General says that the three opinions must be read all together. On the merit of the FAR case, I'm not surprised, but to be honest, I'm quite disappointed by the fact that the Advocate General did not want to analyze the rules at issue in more details. According to the Advocate General, as I said, it is for the referring court to assess whether they have an anti-competitive effect, and whether they may be justified under the Mecca Medina test or under the exception laid down in Article 101, paragraph 3. There is a clear and striking difference between the FAR case and the well-known Bosman case. If you go back and you read the ruling of the Court of Justice in the Bosman case, as well as the opinion of Advocate General Otto Lenz, you will see on that occasion the Court of Justice clearly ruled that UEFA rules on transfer fee and on foreign players were in breach of EU law. The Court of Justice said that the rules at issue pursued some legitimate objectives, but they were not proportionate. By contrast, in the FAR case, the referring court will have the last say on everything. So this did not surprise me, but as I said, I'm a bit disappointed. By contrast, I'm really surprised by the conclusion by the Advocate General on the service fee cap, because the Advocate General said that the service fee cap is not a restriction by object under EU competition law, because this cap applies only in regard to one type of services provided by the agents. This is not true from my point of view. If you read Article 15, paragraph 3 and 4 of the FIFA regulation, you will see that the fee cap applies to any type of services provided by the agents unless the agents can prove the opposite. So there is a presumption against the agents. And this is very surprising, because if you go back again to the Diarra case, the Court of Justice said that the presumption according to which the new club is jointly liable with the player for inducing the player to breach the contract was in breach of the EU law, because it was a presumption, and therefore because it was established without any consideration of the concrete case. So if you compare the Diarra case and the FAR case, I see that a presumption is treated in two different ways, and I really don't understand why.
Yeah, it's quite interesting. As I think we mentioned, I don't think the opinion's that definitive. Obviously, the European Court of Justice will make its decision guided by this opinion, but also, as you ultimately said, the German courts will decide how to implement what comes out of it.
Yes.
I want to ask, there was a decision at the Court of Arbitration of Sport, PROFA, which is an international agent organization, versus FIFA. The Court of Arbitration of Sport made a decision pretty much in favor of FIFA in most parts of that. And I don't want to dissect that decision, but I didn't really read it in these three cases. Would a Court of Arbitration of Sport decision have any impact on, if not the Advocate General, on the European Court of Justice, even though it is a different jurisprudence or a different decision?
Let me make a disclaimer. I am a CAS arbitrator, so what I'm saying is my strict personal view, and is not binding the CAS, of course. This is to be honest. I don't think that the Court of Justice will analyze or take into account the CAS award in the PROFA case. The Court of Justice is within the EU system, is the only interpreter of the EU law. So the Court of Justice is not bound by what the CAS says about EU competition law and the FAR regulation. But let me say another thing concerning the Seren case. The Seren case, technically speaking, is a case about the binding force of the CAS hours in the member states. But on the merits, the Seren case is a case on the compatibility of FIFA bans on TPO with EU law. And if in the Seren case, the Court of Justice will say that the CAS hours is not binding, this means that the Supreme Court of Belgium will have the possibility to assess on the merits the compatibility of FIFA's ban on TPO with EU law. And I would not imagine what could happen if the national judge would say that the FIFA's ban on TPO is not compatible with EU law. We will have a national ruling saying that FIFA's ban on TPO is in breach of EU law, and then we have the most important sports court saying the opposite. This is not good for the sports system at all.
Yes, that's something for us to all ponder. Let's wait for the outcome of the ECJ, and then obviously the German courts will also look at, especially in terms of the two agent cases, FFAR case and the Rogon case, we'll look at that. When do you think the final decision, the ECJ decision, when do we expect to receive a final decision or ruling from the actual ECJ, European Court of Justice judges?
It's very difficult to predict when the Court of Justice will issue its decision. For example, in the Super League case, the court delivered its judgment 1 year later, after the conclusion of the Advocate General. In the Arch case, by contrast, the court took only 6 months to deliver its ruling. I think that much will also depend on how united or divided the Court of Justice is on the FAR case.
Stefano, can I just ask a question from a non-legal perspective, and for many of the non-legal people listening, and they may be asking this, what's the point in having a published opinion? Because in essence, to an untrained eye, it's an opinion, it's a prediction, and I can see the point in allowing those affected by a final decision to almost prepare themselves for the outcome. But isn't it a bit of an anticlimax? And wouldn't we be better just to have a date for the hearing and an estimated date for the ruling and final judgment?
Well, the role of Advocate General within the EU judicial system is a well-established role. That said, we all know that the opinions are not binding on the Court of Justice, but if I may say, in the vast majority of cases, the Court of Justice tends to follow the Advocate General's opinion. Unless the Advocate General adopts a position potentially capable of affecting, as I can say, essential principles of EU law. That's what happened in the Super League case, where, to be honest, Advocate General Rantos went a bit far, saying that the European model of sport is now a constitutional value of the EU system through Article 165 of the treaty.
This is very European-focused element affecting football. But how far-reaching could the final ECJ decision be outside of Europe, particularly for FIFA, which sees itself as a global regulator? In your view, could it create a split world where regulations differ sharply between Europe and other regions and nations?
Well, technically speaking, EU provision on freedom of services apply only within the single market. By contrast, EU competition law may apply extraterritorially. That said, imagine that the Court of Justice will leave the last say to the referring court. In this case, the ECJ ruling has no binding effect, and the final ruling of the national judge, of course, has no binding effect outside that country, in our case, Germany. Therefore, in any case, the Court of Justice, whatever it decides, cannot harmonize rules outside European Union. But please note the risk of a fragmentation of FIFA rules on agents. It's real and concrete, and such fragmentation already exists. As you know, for example, in the UK, if I'm not mistaken, UK is the largest market for agents. The cap on service fee is prohibited. And since the UK is, after the Brexit, outside the European Union, any ruling from the ECJ would have no effect on that market. I said UK, we can say Brazil or another country. So I think that the risk of a fragmentation is real.
Now, this isn't the only big case, big decision we've had in recent times. We've had notably Diarra and Sarang in very recent times, and now these agent-related cases. From your knowledge, are there more potential challenges to FIFA's authority on the horizon in other areas that could affect agents, either directly or indirectly?
Well, let me say that, as the Advocate General said in his opinions, the sports ecosystem and the football ecosystem is a very interconnected ecosystem. So it is easy to imagine that something affecting players may affect also agents, and something affecting agents may also affect football club. Let's say the sports sector is currently under attack. I think you are aware of the case of the Italian Football Federation and the Italian Olympic Committee concerning the ongoing legal dispute between the Juventus Football Club and the Italian sport justice system on the so-called fake capital gains. There are two cases pending before the Court of Justice. FIFPro Europe and European leagues have filed a complaint to the European Union against FIFA match calendar. That's another very interesting case. There are 3 lawsuits against PSG, Manchester City, and the Belgian club Lommel on the basis of the foreign subsidies regulation. This is what I call the new frontier of the relationship between EU law and sports. So I think that, as I said, the sports sector is under attack, not only Europe, but even outside Europe. I also think that the Court of Justice is clearly painting a big picture which we cannot see yet. Up to now, we can see only some dots, and other dots will be added in the very next future. Then we will have to join these dots, and hopefully we will see a much broader picture. This is what the Advocate General said at the very beginning of the 3 opinions, when he said that the present case is a natural follow-up of the ISU, Super League, Royal Antwerp, and FIFA. But I really think that we should wait for 2-3 years to really have a clear picture and then draw some conclusions.
Stefano, you mentioned England, that they've got pretty much their own system, and because of Brexit, they're outside the European Union. The Italian Federation, FIGSI, brought in new regulations for agents. France has more statutory, it's pretty much a profession there, and they've got the 10% cap. They're actually, both those countries are in the European Union. Do you think any decision by the ECJ will affect their systems, which tend to be more individualistic compared to the rest of Europe, or it may not have that much of an impact in Italy and France, who have had their own agent regulation systems for a while now?
Well, I think that it depends on what the Court of Justice will say. If the Court of Justice follow the Advocate General and will leave the last say to the national judge, to the German judge, I don't expect any relevant effect, at least in Italy, but I think also in France. Things could be different if the Court of Justice says something clearer. I mean, something like in the Boston case. I imagine if the Court of Justice will say that the fee cap is in breach of EU competition law because it's a restriction by object, that of course will affect the legislation in different member states. But unless the Court of Justice decides to follow this line, I think that nothing will change and nothing will affect the national legislation.
We know that the current state of the FFAR, quite a few of the provisions are suspended, as well as the Agents Chamber. We know that the cap's suspended and quite a few others. If FIFA doesn't get positive results, do you think we'll go back to the drawing board and maybe issue new regulations based on the opinion or the ruling? Or if they suffer quite a severe loss, because I know it's not just the caps, there are challenges to several other provisions, privacy, multiple representation, etc. If they not lose, I don't want to use that term, but that the court finds a lot of these provisions not in line with European law or competition law, do you think they'll abdicate maybe or remove themselves from agent regulations? Or do you think they'll just issue new regulations with much more of a lighter touch?
To be honest, I think that FIFA will wait until the ruling. That's for sure. I mean, if you read the FIFA statement issued after the opinion, you will see that FIFA is very confident on the outcome of the case. That said, I think that after a careful assessment of the ruling, FIFA will try to amend its rules, if any, to align them with the Court of Justice ruling, provided the Court of Justice says something definitive. Because, as I said, if the last say is left to the national judge, I think that FIFA will do nothing or will try to amend its rules, but in a very soft way. I would exclude a decision not to regulate the agent's activity. It's impossible. As I say, the agent's activity is interconnected with the smooth running of the football competition, is interconnected with the integrity principle. So I think that FIFA will always regulate the agent's activity. I think that FIFA will probably try to avoid a direct fight, a direct struggle with the EU institution, and probably it will try to use soft power, such as lobbying and social dialogue, to pursue its objective. If you compare this situation with the Diarra case, you see the new attitude of FIFA. The FIFA in the Diarra case, at the beginning, FIFA suspended Article 17 of the RSTP. Then it published an interim framework waiting for the ruling. And after the ruling, it started a kind of dialogue with the other stakeholders. So at the time of Bosman, 30 years ago, the situation was totally different. FIFA and UEFA were fighting a real battle against EU institutions. Now everything is changed. There is a stronger relationship between FIFA and UEFA and the EU institution. They talk a lot, and I think the way of lobbying and social dialogue is the true key to find a solution which is benefit for FIFA and for the European Union.
Yeah, that's a very interesting point, because we know that any decision and where to from here, that FIFA have to engage with FIFPro, European Club Association, league, clubs, everyone will be involved if the outcome is one that leaves FIFA in a very difficult position. One last question before I let you go, and this is a hypothetical question. Right now, Stefano, what advice would you give agents, agencies, and other affected stakeholders, coaches under the FFAR? Coaches are also clients of football agents. What should they do while they await the final ECJ decision on FFAR or FIFA's response? Is it just basically stay as they are, or continue practice as they are based on the suspended provisions, or prepare themselves for something different?
Yes, my advice is to wait until the ruling, for two basic reasons. First, as I said, the Advocate General opinion is certainly important and relevant, but it's not binding. So anything can happen. Secondly, it is important to see whether the Court of Justice will rule that FIFA regulation or part of it is in breach of EU law, option A, or whether, much more probably, will leave the final decision to the national judge, as done in the Diarra case. Nothing new under the sun. If the Court of Justice chooses option B, as I say, technically speaking, the preliminary ruling is not binding. And of course, the final decision by a national judge is not binding the judges of the other member states. So my advice is that this is not the time to make predictions. It's better to wait for the ruling, and then we will think about the possible scenarios. This is not time to draw conclusion. This is not time to act. This is just the time to wait for the ruling. This is my point of view, of course.
Yes, and from the agent's perspective, I would say that a lot of them want to see at least the agents chamber come on board, which unfortunately it hasn't, because a lot of agents do have disputes with other agents or clubs or players, but that's another thing. Thank you so much, Stefano. Really appreciate you coming on. I know you're busy. I know you're in demand with a lot of different stakeholders and different people want to speak to you about this case. Hopefully we get an answer soon, but really appreciate your time coming on the agent's angle. Thank you.
Thank you very much. It was a privilege to be invited, and thank you very much again.
That was a fantastic interview with Stefano. He's one of the most respected and in-demand scholars and experts on EU law, including EU competition law. It was great to have him on the podcast. In essence, Stefano reiterated the following key points. There obviously were three opinions in the Advocate General, the RRC, the Rogon, and the Portuguese team CD Tondela, but we're not going to focus too much on that. And really, these cases follow a similar rulings. We talked about Super League, we talked about Diarra, which was a FIFA case. Very similar legal economic issues that now concern the FIFA Football Agent Regulations. Now, observations. Agents' remuneration was one I think that Stefano focused on, and that the FFAR's fee caps can be transparent. Joint purchasing was mentioned in the opinion, and they're not restrictive by object, which is a key matter. We'll break that down. So we mentioned the Mecca-Medina tests, and just to explain that very simply, any restriction, and we're talking about the FFAR, but not just the caps, must be necessary, proportionate, and pursue a legitimate public interest. FIFA to win the case must meet those criteria in very simple terms. Now, if they don't, there's also the option of efficiency gains, and this was mentioned briefly. Gains must be shown to be real significant, contribute to economic progress. So these rules improve the economic competitiveness. There's gains for everyone. And if it can be shown that, they might be allowed through. So there's a lot of dynamics there. Licensing, very simple, and I think everyone would agree with this. A licensing system does not equal anti-competitive behavior. That's quite important. With multiple representation, and it was touched on here, that restrictions aim to avoid conflicts of interest, but courts must assess if there are other avenues or alternatives that exist instead of banning multiple representation. That's important. I would say with Rogon case, and this is also touched on by Stefano, that agents' role, there's an impact of integrity and fairness in football, and the regulations can fall under legitimate objectives in the sense of being able to regulate that integrity and fairness. And I think Stefano touched on this as well, that in a very general way, the Advocate General does not rule out that the FFAR rules entirely. I don't think they will entirely survive, but emphasise that any restriction that is in place must be justified, proportionate and necessary under Mecca-Medina. So FIFA being a private regulatory power, as we like to call it, they're under scrutiny. But if their regulations meet EU competition and internal market laws, and some of these provisions in the FFAR will survive. But everyone's sitting a little bit on the fence here, Jonathan, because the AG's opinion describes what needs to be considered, what's the law, in other words, but doesn't put a lot of the facts in. And that's why we're relying on the European Court of Justice. But I think Stefano really broke it down and covered a lot of the key issues. And we're glad for that because he is one of the experts in this space.
Now, I'd like to say that when you take time to read and digest the AG's opinion, you start to develop a clearer picture. But in all honesty, I'm now waiting for the opinion on the opinion. So it's rather comforting that experts like Stefano and many others also recognise, shall I say, the vague nature of the AG's opinion in this instance. And from listening and reading the views of several legal experts on this opinion, or what will be the outcome, I've observed those lawyers from a more academic or EU-centric sphere have a contrasting view to those in a more practice and sports sphere. And to an extent, the opinion itself seemed to encapsulate those two favourite words of many a lawyer. When you ask them for an opinion, they reply, "It depends."
Well, yeah, and this decision, and you probably agree with me, Jonathan, we don't agree on a lot of things, but we do agree on many things as well. It's a 50-50. It depends. I mean, it is an it depends opinion. The way it's the three opinions handed down by Advocate General Emilio, it depends on the way they will apply the facts and the evidence and the submissions and obviously set it out. So it depends. I agree. Two words that really interest me that the Advocate General mentioned is upstream and downstream markets, and that the rules in question, that is the rules in the FFAR, affect upstream or downstream markets. What do we mean by that? The market for agent services or the transfer of players. And these rules are subject to the EU competition rules. That was in the opinion, even if they're adopted just by sports association, which FIFA is. So that is very important, that the upstream and downstream, as was explained, the agent rules or the market for agent services are definitely affected. And yeah, it's going to be very interesting. I want to look at someone else who made some observations here. I want to keep it very simple that John Mazzard, who's a King's Counsel in England, very well known in the sports law space, he made it very clear that the advisory opinions are not decisions of the Court of Justice. The court itself will now review the references. He also mentioned that in one of the cases, the European Super League case, the Advocate General Rantos's opinion was not followed to the nth degree. So there's a lot of leeway here for the court. And he reiterated that no party can declare victory at this point. Now, He also emphasised that the Advocate General opined that the agent regulations are not restricted by object, which is a big step for FIFA. That means that if they are restricted by effect, that's a factual question. But if FIFA can justify under the Mecca Medina principles, it's a three-part analysis. I'll break it down. Very simple. Do the FFAR rules pursue a legitimate objective in the public interest? Is there a restriction inherent in the pursuit of that objective? Does the rule go no further than necessary to achieve that objective? Very simple. So are they going too far with the rules, or is it just about right in the terms of the public interest, in terms of transparency, in ensuring that the market remains competitive, whatever it is? Has FIFA got the balance right? To keep it very simple. It's interesting that this opinion is contrary, and this was raised by John Mazad as well, very important observation here, is contrary to the Premier League Arbitration Award in the CA Basin. There was 3 other agencies involved versus Football Association and FIFA, which found that English FA's proposed agent regs on the cap were anti-competitive restriction under the UK competition law. So the AG's taken a different approach here in relation to this case. Now, everyone knows that if FIFA, and it's not just FIFA, but the German Football Association, if they succeed before the EU's national courts, then there will be a fragmentation. And this was raised as well in our discussion, that the regulation of football in Europe will be different to the UK, and it may be even different to other places like China and Australia, which don't allow caps generally in their economic markets. So we're going to see, even if the decision goes FIFA's way, what's going to happen. But also, we mentioned what will happen to the French and Italian regulations. That's another thing. So there's a lot to play for. I don't want to give any indications. I just think that it's now very important that the European Court of Justice gives clear-cut guidance and decisions on these regulations, Jonathan.
Now, yours and Stefano's comments and observations of the AG's opinion, both being from the legal profession, are arguably far more educated and applicable than mine. But that doesn't mean that non-legals can't make, shall we say, more nuanced observations of this opinion. So please bear with me here on this one, Peter, with what may be somewhat left field observations from a non-legal perspective. And I'm going to try and refrain from pleading a case or scrutinising and identifying the flaws in the FFAR, because frankly, I've done enough of that over the years and we are limited on time. So first of all, the more general aspects and the way in which the opinion has been compiled and released, as I said, I found this strange being grouped together, if not confusing, because yes, they are connected matters, and I get how the underlying laws overlap. But for me, these cases, from an agent perspective, address somewhat different objections, approaches, and topics. And I'd even say that to an extent, the 2 agent cases, I personally view very differently in what they're trying to achieve and their approach. Now, a big factor, as you mentioned, in these matters with regards to the EU ruling is the sporting exception and the Mecca Medina factor. And under point 22, the AG states that in his view, the sporting exception aspect encompasses, by and large, the basic rules of the game and some organisational aspects of a non-economic nature, which I think is a great explanation for non-legals as to how that applies. But maybe I'm being a bit daft here, or naive, as I can't see how the bulk of FFAR falls under sporting exception in that case. Because arguably, it's only the link to the likes of the RSTP and other FIFA documents that makes the FFAR subject to the sporting exception rule. Plus, to add to that, it's quite rare that agency activity is of a non-economic nature. So is there a valid viewpoint there as to why we are even talking about sporting exception under EU law for the FFAR in itself? The other striking thing for me after some reflection on the AG's opinion, and something that we touched upon with Stefano, is that this opinion could be interpreted as almost giving its blessing for the ECJ to allow the referring courts in Germany to make their own judgment on the cases, which some argue would have huge ramifications for not just football regulations, but also sports law and EU law, if the ECJ did not give, shall we say, quite a rigid set of guidance or strong ruling to the referring courts. Because the belief or fear, depending on your position, seems to be that if that was the case, it would largely result in a ruling from Germany that would be largely against FIFA and the FFAR.
Yeah, I mean, this is a big question. The German courts will take the observations and the court decision from the European Court of Justice and then implement that decision on the German cases. And obviously, that will ultimately also affect the rest of Europe, no doubt about that. We do have anecdotal feedback that some of the German judges see the FFAR as somewhat restrictive on competition. However, if the European Court of Justice allows several provisions to stand, like the cap, multiple representation, then the German courts will have to follow the same interpretation. It all comes down to the European Court of Justice being clear-cut on what the European competition law says, or whether FIFA's been able to show that what they've implemented is reasonable and have met the Mecca-Medina test, for instance, which we discussed earlier. Because in European law, there's a prohibition on the dominant position and abuse of that. And FIFA, being the regulator and the implementer of these, can't abuse their dominant position. But also the argument of agents, and this is one of the other articles, it's Article T56, that they want the freedom to provide services without restrictions. And the ECJ will be looking at that, and they're important. But you mentioned sporting exception. If the Advocate General rejected any notion of that general sporting exception, because that will place sports regulations beyond the reach of EU law, and I think it's very important, especially with the FFAR, they do affect economic activity. We're talking about agents involved in getting in employment for players, in transfers, in getting commission and caps. That's all economic activity. I agree with you. There's no doubt about that. Now, also from reviewing the cases, I agree with you. There's 3 cases here, and the way you read them is you have to go to the other cases, other paragraphs. That's quite cumbersome for many, because in essence, you have to cross-reference the paragraphs of each case. Not at all cases, but to get the full picture, you have to go to the paragraphs of the other ones, what they say. So that is very unusual. Maybe because it was 3 cases referred, I don't know, but it's a hard one because if you're not a lawyer, it can be hard to understand what fits where, in other words, Jonathan. So I agree with you there as well, that you're moving different pieces around. So that's why, and we've said this before, the European Court of Justice just got to come out and be definitive in its decisions so we can move on and have a final piece of the puzzle. What's in, what's out of the FFAR?
But the big talking point, arguably, is the cap on agent commissions. And I've heard several interpretations from legal and academic types on this. And largely, the opinion is that the AG does not find the cap to be one of the restrictive elements of the FFAR, for which I don't necessarily agree with that interpretation, but I can see the way in which FIFA and their legal team has probably spun the representation of the cap. After all, FIFA have more spin than a politician on a merry-go-round. And point 63 is interesting because it reaffirms this non-restrictive view on the cap. As the AG seems to intimate, there is no cap in effect. And what cap there is a dynamic cap, because a higher transfer fee or player salary would allow for an increase in the agent commission. And therefore, technically, the cap isn't a cap. So in isolation, that may be true, but there are other elements to consider within football and the agents industry, such as cost controls that limit such variations, if not turn this cap on agent commissions indirectly into more of a hard cap. And if that is what the AG is legitimising, that it's dynamic, it certainly doesn't help the complaint we hear so often from the wider football community of increasing transfer fees, player salaries, and the desire we hear for more fiscal responsibility in football club spending, something which FIFA even refer to at times. However, one of the arguments made against the cap on agent commissions I noted in point 66. Where the AG refers to what many agents and agents associations have been saying with the cap, and that is the inherent risk that standards and service provisions from agents to clients will be lowered. And although that's countered somewhat with, as you said, the reference to non-agent or other services being allowed and thus falling outside the cap, which of course is disputed, as Stefano pointed out, I think the point is missed in the AG's opinion on the matter of potential conflicts of interest and disguised payments through so-called other services. And whilst the cap may be adjudged to be compliant and non-restrictive, point 56 in the opinion interestingly seems to intimate that by imposing a cap, the aim of FIFA with the cap may be clear, but the impact is not obvious, and almost implies that the capping element may not have been properly considered when developing the FFAR, and may even at points be implying that there are better ways to achieve FIFA's stated aims and objectives through things such as the cap. And that nicely leads me on to point 64, which I think is one of my favourites, so to speak, because the AG's opinion seems to place a very large question mark over the objectives pursued by FIFA from the FFAR. And for me, actually questions the economic rationale by FIFA in how they've set the cap, how FIFA measured and quantified the cap, something many have been asking for years with no adequate response. And some have even said they believe the numbers were plucked out of thin air by FIFA at random. Plus, as it does at several points in this opinion, the AG refers to a lack of information from FIFA.
That's interesting because you look at the opinions, but you also got to look at the footnotes or the end notes, which talk about which cases are being considered, but also talk a bit about what was on the case file. And if that's the case, that last observation you make that there's a lack of information from FIFA or even the agents, I would have thought in this case, you would have had really good economic modelling. You would have experts' reports on how the cap affects one way or the other from both sides, from FIFA, also the German agent's side. And that should be on the case file because as much as it's a legal argument, we're talking about competition law, which is also economics, how it affects the economy, how it affects the market, more importantly, in the marketplace for agent services. So I would have thought a lot of that information would be provided. So I'm a little bit surprised that the AG would say there's a lack of information, which should have been there because this is one of the major issues covered in the FFAR cases, the cap. Now, I will say that the AG's opinion, I've also read that, and you mentioned this, that the cap remains a dynamic maximum, not a hard ceiling. So the AG believes it's not a hard ceiling, that price competition is not eliminated because, as we've mentioned, the clubs can still compete for talent through higher transfer fees or salaries, which indirectly maybe increases agent remuneration. However, the AG also mentions, and this is where it's a 50-50 draw, that there could be potential adverse effects, especially if agents become disincentivized for presenting less lucrative clients, such as youth players or players on more modest salaries, because that's in the RAC Sports opinion. And that's also what we've discussed previously on our podcast, that a lot of people may be moving to the more lucrative club agent side because you got the 10%. So is the way this cap structured doing that? So that's going to be looked at a little bit too. To be compatible with EU law, the cap must serve more than economic convenience. And that's very important. I think there's got to be some other legitimate aims for the cap that FIFA have to put forward, like, for example, preventing conflicts of interest, as was mentioned in the opinion, protecting young athletes. But also FIFA will have to prove that there's not many other alternatives than this type of cap to be considered by the courts. So that's another thing. Now, I will say this in simple terms, it doesn't seem that the cap is inherently unlawful on the agent remuneration, but if it's found to restrict competition, then it may be. So it depends on what's presented. And I would have thought it would have been a stronger opinion against the cap by the AG, the Advocate General, but that's not the case. Now, one final point. The burden's going to lie with FIFA and its member association, which is the German association in this one, because they were a party to the German cases, to demonstrate the factual and legal necessity of each measure, which includes the cap, and show that no less restrictive alternative would suffice. So the burden we've got to remember is on FIFA here to justify its FFAR provisions that relate to capping agent fees, multiple representation, etc. So it's FIFA who have to prove what they've put together in very simple terms is justified and fulfills EU law.
We'll put the one C word, the cap, to one side and replace it with another C word and another disputed factor with the FFAR, and that is consultation. And that, for me, doesn't escape the AG's attention either in the published opinion. because point 62 in the AG's opinion comes with the tired and frustrating FIFA narrative of nonsense. There we go again. I better trademark that persists on so-called consultation. And the wording here is likely lifted from FIFA's own representations in the case, that a number of agents and associations of agents were heard by FIFA in the process that led to the adoption of the FFAR. And that is referenced in the AG's opinion. But as we and many others are all well aware, for the majority of the time, FIFA may have listened but didn't hear and just did what they wanted. Even huge question marks are now understandably being drawn over those agents and agent associations FIFA claim were consulted and the results of those consultations. So this hugely frustrating and annoying consultation myth persists as part of this narrative of nonsense from FIFA and continues to be a core problem in this ongoing saga. And it needs to be addressed because FIFA can repeat it all they want. But hand on heart, I don't think they can truly and objectively say they believe it, let alone prove it. But sadly, it does appear that based on this opinion, the AG may have fallen for the FIFA consultation claim.
Even Stefano, I guess, is of the view that consultation matters. Lack of agent involvement in rulemaking can undermine the justification for certain rules. I think that is an important consideration. Now, if the Court of Justice rules against FIFA, there has to be reversal or modification of key FFAR provisions, and there's got to be greater freedom protection for agents in terms of remuneration and privacy as well. And I want to mention privacy very quickly, Jonathan, because I think that's important. One thing that was clear with the opinion was the data protection concerns that agents had, that the FFAR requires agents to submit sensitive personal data about agreements with clients, remuneration, collaboration with other agents, and this has to be disclosed to FIFA within 14 days. And the court questions whether this complies with the GDPR, which is the privacy laws of Europe, which governs the legal base for processing personal data. I think that aspect of the opinion is quite definitive. It attacks FIFA's need for all this information. And it's very important in terms of the privacy of agents that is dealt with as well. But the Advocate General proposes a nuanced rule-by-rule approach, that some provisions, like, for example, the prohibition on agents soliciting clients under contract, are not legitimate in the public interest and anti-competitive. I think that's going to go down, where, you've got the rule that you only approach a client within the last 2 months. That looks like it may go down. But one other thing we haven't addressed is the licensing, the requirement to be licensed. And according to the opinion, not inherently anti-competitive. We know that under the FFAR, agent must pass an exam to obtain a license. The Advocate General accepts that licensing is widespread in regulated professions, and that although there are some concerns with private rules like FIFAs, generally that's only when the license is excessively onerous or lacks transparency, or you limit market access. And I don't think that's the case here. I think the license system, if it aims more at qualitative selection, we've got an exam, probably be sustained. So that's one thing that may survive. That is the licensing system and the ability of FIFA to be the regulator as well. So there's a lot of issues here, not just the caps, but a lot to consider in this AG's opinion. And more importantly, when we get to European Court of Justice court decisions, Jonathan.
And quite rightly, in the AG's opinion, there's repeated references to the likes of legitimate objectives, rules being strictly necessary and proportionate when it comes to the FFAR. But point 71 is such an example where the AG highlights the vagueness in the regulations and legitimacy presented by FIFA with the FFAR. And I interpreted this as the AG possibly flagging it up to be considered by the courts, either the ECJ or the referring courts in Germany, even to an extent of possibly questioning, amongst other things, the proportionality of the FFAR. But one element of the FFAR that does seem to have been challenged successfully is the regulation on approaches by agents to players and clients. And for me, I actually agree with FIFA on the necessity for such a rule, although I don't agree with the way they've tried to implement it with FFAR. And under point 109, the AG clearly sees the approach to the problem as anti-competitive, which I agree with also. Now, my view may seem quite contradictory in that I agree with the aim, but also agree that the approach is wrong, even that this may be restrictive. And this is because of the way the industry is. Something like this is needed, and I sometimes refer to it as an anti-poaching rule for agents. But I know for a fact that FIFA were given many other suggestions on how to address such underlying issues with the FFAR, but they chose not to take a more measured, thoughtful, and non-restrictive approach. But I suppose that's what you get from so-called inclusive consultation. And I think, like on so many aspects of agent regulations, FIFA made a total pig's ear of presenting what they're trying to achieve with this regulation on approaches to players and clients, and also the implementation. Is that, dare I say, because they don't truly understand the football agent industry, an accusation made many times during the FFAR saga. But for me, this area of the FFAR is pretty basic stuff to address in a fair, effective, and non-restrictive manner.
As I've said before, I think two things look like they're not going to survive. And one is, you mentioned the FFAR prohibits agents from contacting players under an exclusive agency agreement, unless it's the final 2 months. We mentioned this. And the Advocate General is unequivocal. He rejects FIFA's argument in relation to this, that this rule provides contractual stability. He notes that stability between agents and clients is not comparable to that between players and clubs, and it doesn't serve the public interest. So that's going to probably get knocked out. I did mention the information sharing obligation disclosure, where FIFA obliges to upload personal and contractual information to FIFA's platform. And this is a danger here. And the AG's also said this, that this information can be shared with third parties, especially agents' commercial data can be available to rival agents or clubs. And this not only undermines the confidentiality, which the AG alluded to, but the trust in the regulatory system. So that's two areas I would say that FIFA is going to have problems with, substantiating those rules. But as you mentioned, there are a lot more issues in terms of whether these FFAR are anti-competitive. We will see down the track how the ECJ deals with all that. But it's going to be an interesting time. We're just going to wait and see. And as Stefano said, at the moment, agents should just be careful, continue with their business and not be too, not say worried, but just not feel like they need to change things, not until we get a definitive decision by the European Court of Justice on these rules. And take into account, they still need to be licensed. At the moment, the caps are suspended. And in terms of approaching clients, take into account the circumstances. So it's business as usual at the moment.
And just to tie up a few loose ends, some other things I noted, a very important point for me, as many will know, is addressed somewhat in point 118, and that is, it seems the AG highlights agents as important stakeholders, although he doesn't actually say it. So why don't FIFA and others recognise agents as official stakeholders? There's also some interesting references to Italian legislation and regulation towards the end of the AG's opinion, which is prevalent not least because the Italian regulations are sat largely independent of FIFA regulations for many years. Plus, in recent weeks, we had those developments from the FIGC, which we covered on a past episode. And point 30, it seems that the AG clearly acknowledges the need for a governing body for the sport, which I again agree with. Some don't, and hence there are some who argue over FIFA's legitimacy to regulate agents. But I would caveat that opinion from me by saying that I and many others don't just want any FIFA. We need an effective, transparent, and fair FIFA that don't make such a hash of things like the FFAR, which we seemingly don't currently have. And just to wrap up, points 153 and 154 were very interesting, but they may go under the legal radar somewhat, solely because they're quite general, if not simplistic and non-technical, which is my area of expertise, simplistic and non-technical. But the AG seems to be directing the judges and courts to the fact that they should be cautious in considering whether FIFA are taking legitimate, consistent, and proportionate steps with the FFAR. But more importantly, it should be considered whether one, the rules truly pursue the objectives of FIFA in a consistent and systematic manner, and two, whether there are any hidden motives behind the regulations and the approach. These present big questions over both the FFAR itself and FIFA's approach to the FFAR process. And in closing, I will quote directly from the AG's opinion one last point, which I think from an agent perspective could be taken in a positive light on the overall cases. The referring court should also ensure that the rules at issue are proportionate in the sense that they strike a fair balance between the interests FIFA wishes to protect and those of the agents who are adversely affected by them. That would not be the case, for example, where a rule does indeed pursue a legitimate and valid interest, but regardless of whether alternative measures exist. The burden imposed on the agents for that purpose would, at any rate, be unreasonable and excessive. On which I think there are a plethora of legitimate arguments as to why that is not the case with the FFAR as a whole, or the approach that FIFA have taken with the FFAR.
Very interesting quote, Jonathan. I don't want to overanalyze the opinions or times three anymore. It's an intriguing time ahead. We have to wait for the European Court of Justice. The final judgments, as someone said, are now awaited with even greater interest. The International Sports Law Association had a bit of a talk about some of the questions that the courts have to answer. And I think the agents, especially our agent listeners, really, this is what they really want to know. They want an answer to these questions. And I'll just give three. On agents' remuneration, are the FFAR rules that limit how much agents can earn unfair or harmful to competition? They want to know that. And another question about the agent remuneration, they want to know from the court, could the rules, the FFAR rules, hurt less wealthy agents or even clubs? And then I'll go on to multiple representation, which is also a big issue here. And there's one question. Are the FFAR rules limiting agents from representing multiple parties in the football transfer necessary to prevent conflicts of interest? Or do they unfairly restrict competition of savvy deal-making type agents? That's what the agents want to know. And in simple terms, answers to those questions, which then would see changes or not to the FFAR rules on caps, multiple representation, and we've talked about a few other topics as well. Now, I just want to refer very briefly to two interesting matters to high-profile players and provide some talking points or some thinking points and challenges for agents before closing. I want to talk about the Mbappé and Paris Saint-Germain dispute. The 55 million unpaid compensation is heart of a legal battle between Mbappé and PSG. We know that Mbappé left PSG on a free transfer to Real Madrid in 2024. And this is conflicts which arise from a verbal agreement made in the 2023-2024 season that PSG claims justified withholding of the $55 million payment that Mbappé says is owed to him. There was a French committee, a legal commission, said you need to pay Mbappé this, but PSG refused. Now, what I'll say is this, verbal agreements, and a lot of us use these, are legally valid in France, but it's very risky if they're not formalised. Now, why I raise this one? It's the implications for football agents. Very important. We know this dispute's going on and PSG are relying on verbal representations, but it's important for agents going forward to the next transfer window that we have clear and thorough contracts are essential to avoid ambiguity and disputes. Get everything in writing. And when agents are involved with verbal representations are made to them, they should push for binding and enforceable, I would say, not just paperwork, but also dispute resolution mechanism. I know in this case, Jonathan, which may pique your interest, that Mbappé, I believe, did not want to go to mediation. So it has to go to, I suppose, to the court system. But what I will say for agents, avoid reliance on verbal agreements or non-binding recommendation by staff of a club. Very important in all your negotiations. One other case, very briefly, Paul Pogba. We know he's returning to football after 18-month suspension. He'll be able to play if he finds a club since his departure from Juventus. It's going to be interesting to see what kind of contract is offered. And as an agent, we've got to look at this. We're going to be in these scenarios. he's going to have a contract that's going to have very specific clauses. Besides medical examination, also performance-based compensation. He may not get salary, he might be performance-based, and also legal guarantees that there are no similar sort of conduct. So these are scenarios that we have to deal with as agents. And I thought the Pogba and the Mbappé scenarios or cases are things we should keep in our mind, especially going into the window. And when we've got very unique circumstance with players that we're trying to transfer. And these are two high-profile examples, but I think we need to understand that we're going to face these challenges. And it's good to follow these cases, how the Pogba goes if he gets a new club, and how the Mbappé case goes. Obviously, he had no contract, finished his contract and went to Real Madrid, but there was an agreement or not about the remaining compensation for Mr. Mbappé. So very interesting. It's been a good episode. It's been actually quite complex episode, one of our most complex. It's hard to break down legal opinions, Jonathan, but we'll leave it at that. It's a bye and farewell from me.
And as we edge towards the end of the second season of the Agents Angle, like a team desperately clinging onto their qualifying spot for a cup competition next season, we have just 2 more shows to go. No, we definitely won't be hanging on for the actual judgment from the ECJ this season. Not least as much more mention of the likes of FFAR, ECJ, Mecca Medina, or the phrases by object and by effect will leave me needing medication or professional help. The next scheduled episode of the Agents Angle will be in 2 weeks' time, the 8th of June, and we have another guest interview for that episode, which I think will open a lot of eyes and ears, address many misconceptions, and answer a lot of questions those in the industry may have. And that interview is with a representative from an organisation we've been trying to get on the show for quite some time. And I think most listeners will find it very insightful. So until then, the FFAR saga rumbles on. So take care and bye for now.
The purpose of the Agents Angle podcast is to provide news, information and facilitate discussion on regulatory matters, policies, business trends and issues affecting football agents worldwide. The opinions and recommendations presented in this podcast are for general information only and should never be considered legal or professional advice. Furthermore, the views expressed by guests are their own and their appearance on the program does not imply an endorsement of them or any entity they represent. Thank you for listening.